I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Blues. Welcome back, everyone. I'm Alice, and I'm joined, as always, by my gracious co-host, Brett. Hey, Brett, how are you?
Hi, Alice. I like how we start recording and you just dive straight into it. There's no chit-chat beforehand or anything. It's just, we're just going. We're going into it. I like it.
I mean, is it fair to say, is it fair to say that we've been chit-chatting all day at work already? So this is just like hour 12 of me talking to you.
That's true. That's true. I just like your efficiency. It's just, I'm all like lackadaisical and we're barely getting through anything on the other one. But when you take charge, it's like, no, we're getting into it. We're doing this.
Well, here's the thing. So I love summertime because I try to leave work right on time so I can rush home since we have more daylight and take my boys to the pool before bedtime. And so it's like a very small timeline because we're only there for like 45 minutes, but it is their life is just made when I take them to the pool on a weeknight. And so I feel like on these weeknight summers, I'm like, go, 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 just so I can make sure to kind of fit in all the fun, which I recognize how ridiculous that sounds, that I'm scheduling my fun. But I'm kind of still in that mode right now because I just got the kids to bed, and I guess that's why I'm...
If you don't schedule the fun, there won't be any fun.
I don't know.
Mark it down, put it on the schedule.
I don't know how good that is for my life, that I have to schedule in the fun.
I think it's wise of you to do it. I mean, we don't have a self-help podcast here, but if we did, I think scheduling in time for fun and frivolity and everything else, because otherwise your calendar will be full of not fun, and nobody wants to do not fun. I mean, I know that this podcast is the most fun thing you do.
Thanks for that's why you're gracious, right? You're gracious because I think that I do schedule my fun literally on my calendar. And thanks for not making me feel ridiculous.
Never, Alice. Only behind your back. So, well, Alice, I mean, we're doing Adnan Syed today, so I don't really know what else to say. I don't think it needs a lot of build-up or anything like that.
I say that I don't know how many times we have said we're not going to do Adnan, and we are absolutely doing it now. So it's good that we have a second podcast to do all the shows that we don't have time to do on our other podcast.
And let us just be clear, we're not going to cover the entire case here in a 30-minute episode on Legal Breeze. We've got a very specific thing we're going to talk about today. One day, sometime in the future, we'll spend 5, 6, 7, 8, 9, 10 episodes on this case. But today, we have a very specific thing we wanted to do. Last week, we talked about ineffective assistance of counsel, and ineffective assistance of counsel played a big role in this case. If you listen to Serial, you remember that there was a lot of questions about how Syed's counsel handled certain information that she received during her sort of investigation of the case, and really how she didn't handle it, and information that she never looked into and didn't put on. And through the lens of this very famous case, you can see how some of the principles we talked about in the abstract last week work here. One thing I did want to mention, someone asked, if you're pro se, can you be ineffective? And the answer is no. That would be pretty funny if you could be. If you could just represent yourself and do such a bad job that you get another trial if you win. Now, you can be not competent to represent yourself. And I actually, in my day job, my most recent argument in front of the Court of Appeals was about that very question, about whether or not someone who represented themselves was competent to do so. But if you are competent to do so, and there's a whole test, and you can go into that about whether or not you're competent to represent yourself. But if you are, then whatever happens is on you. If it goes wrong and you don't do a good job, you made that decision with your eyes wide open. So no, you can't be ineffective if you're representing yourself. But if you're someone like Adnan, who has a lawyer who is working for them and is supposed to be doing a good job, they certainly can be ineffective. And we talked last week about the standard that you have to meet, this deficient performance and prejudice, and we're going to talk about that a lot today through the lens of this case.
Right. So just to give you a little bit of factual background before we dive into these principles, I think most of you know the story, but if you don't, Hae Min Lee was last seen on the afternoon of January 13th, 1999 at Woodlawn High School in Baltimore County, Maryland. Less than a month later, on February 9th, 1999, Hae's body was discovered in a shallow grave in Leakin Park located in Baltimore City, Maryland. Following an investigation, police identified Hae's ex-boyfriend, Adnan Syed, as a suspect. Here's how the appellate court described the case, and this is a quote from that opinion. The state theorized that sometime before the school day ended on January 13th, 1999, Syed asked Hae for a ride so that he could pick up his car at the repair shop, knowing that she would say yes. During that ride, Syed, a regular operator of Hae's Nissan Sentra, drove them to the Best Buy parking lot situated off Security Boulevard in Baltimore County, a location frequented by them during their courtship. Central to the state's theory was that Syed murdered Hae between 2:15 p.m. and 2:35 p.m. in the Best Buy parking lot by strangling her and then placing her body in the trunk of her car. The state adduced evidence showing that later that night, Syed and Jay Wilds, the state's key witness, buried Hae's body in Leakin Park.
Right, so that was the prosecution's theory, and as you can tell, I mean, this is a tight timeline. We talk about timelines all the time. Timelines are important to us in the way we tell stories because it structures your narrative and it gives you things to hang evidence on. People think in terms of timelines, and often prosecutions will want to give juries a timeline that they can think about, but this is a tight one. You have the prosecution essentially saying this murder occurred in a 20-minute period between 2:15 and 2:35. And one of the reasons for this, Jay Wilds actually had Adnan's cell phone. At around 2:35, I forget the exact time, but in this time period, that phone received a call. Now, this was 1999. Cell records today are really good. At the time, they weren't so good. Incoming calls, you could get the time that the incoming call came in. You could get the length of the call, but you did not get location. You didn't get who was doing the call. But the state theorized that this was actually Adnan calling from the Best Buy parking lot from a phone booth, something you kids probably don't remember, but a phone booth where you actually took change and you put it in there and then you could make a phone call. That he called Jay Wilds to say, hey, come to the Best Buy and meet me here. And then when he got there, he shows Jay the body in the trunk, and the two of them go off, and over the course of that day and night, determine what they're going to do with her body, bury the body, and then Jay becomes one of the biggest witnesses in this whole case. But the prosecution has created a weakness in their own case by stating the timeline such that it is, by giving a 20-minute window where they are saying this murder occurred. That means that if Syed can come up with an alibi or some sort of evidence that he could not have been at the Best Buy murdering her in that 20-minute window, if he can find an alibi for those 20 minutes, then he can't have committed the crime. By the state's own theory, he would have to be innocent, and it turns out that he is able to locate some evidence eventually that just might provide that alibi he is looking for. In 2018, so 20 years after this murder and many years after Syed is convicted of the crime, the Court of Special Appeals in Maryland issues a bombshell opinion. Adnan Syed, the convicted murderer made famous by the Serial podcast, was due a new trial. And the reason for that is ineffective assistance of counsel. And this goes back to that timeline we were talking about. So during this trial, you have the prosecution putting forward this timeline. So Adnan, he has to kill his girlfriend. He calls his accomplice, Jay, tells him to come to the Best Buy, shows him the bottom of the trunk. They go off to bury the body. But there is that problem. What if Adnan could show an alibi for that time? And sure enough, there is a witness named Asia McClain who would say that she saw Adnan in the public library near the school at a time utterly inconsistent with the prosecution's timeline. This testimony by itself could provide an airtight alibi for Adnan. If it's true that Asia McClain saw Adnan at the library at 2:20, for instance, then he couldn't have been murdering Lee. And he couldn't have gotten out to the Best Buy to murder her by 2:35. And if you remember Serial, this was a huge part of this. You know, they're trying to figure out where everybody was at the time. They're driving the car from the school to the Best Buy, trying to make it as quickly as they can to figure all this out. And it turns out that this is pretty powerful testimony. If McClain is right, then it would seem like, at least according to the prosecution's theory, Adnan would be innocent. And McClain wrote a letter, actually wrote a couple letters to Syed saying that she had seen him in the library that day and asking for his lawyer to get in touch with her. And Adnan gave those letters to his lawyer. But here's the thing. It is pretty much undisputed at this point that his counsel never followed up on those statements. She never talked to McClain, and so the jury never heard it. Now, this is important. We talked about last week the standard, this deficient performance, and we talked about how strategic decisions are not included under this. And it became pretty obvious after Strickland came out that most of the attacks on people's convictions were really strategic in nature, and defendants were losing a lot. And so post-conviction counsel and defendants in their own habeas petitions were starting to figure out, if we're going to attack this, we have to do it in a slightly different way. And they came up with a failure to investigate theory. So the failure to investigate theory says, if you're a lawyer, you have a duty to do some investigation into your client's case. And if you don't investigate, that itself is deficient. And because you didn't investigate, you can't really say it was a strategic decision not to include the information you might have discovered if you had have investigated. So imagine in this case, if the lawyer had gone to Asia McClain, talked to her, took a statement, and then decided later on, you know what, not going to include this. There are some problems with her statement. There are some contradictions between what she's saying and what Adnan initially said to the police. Could hurt us more than it would help us. Not going to bring it in. If she had done that, no chance you're going to succeed. That is a strategic decision, tactical decision, the kind of thing lawyers do. But by not investigating at all, she opened herself up to this ineffective assistance claim. And this court in 2018, 20 years after all this happened, concluded that under Strickland, the case we've been talking about, the failure of this counsel to investigate this evidence was deficient and that it prejudiced Adnan. And I'm going to read you what they said. And this is lengthy, so bear with me. Specifically, the duty in question here is trial counsel's duty to investigate a potential alibi witness, and the issue raised is whether trial counsel's failure to investigate McClain as a potential alibi witness was deficient performance under Strickland. In the case sub judice, which is the kind of legalese you should never use in your writing, all of you aspiring lawyers out there, which just means in this case, Syed identified McClain as a potential alibi witness and requested trial counsel to contact her. Syed gave trial counsel 2 letters written by McClain. The first contained McClain's phone number and her grandparents' phone number, and the second contained McClain's address in Baltimore. In the first letter, McClain reminded Syed that she had talked with him in the Woodlawn Public Library in the afternoon after school on January 13th, 1999. and that she may be able to account for his quote-unquote lost time from 2:15 to 8 o'clock that day. This is an important thing. Adnan basically said, look, I have no idea. Might have been at track practice, might have been somewhere else. Don't really remember. That was what he said. You can debate whether or not you think that's believable. Probably depends on when he was asked. Most people can't. You asked me what I did a week ago, I'm not going to be able to tell you. Anyway, she also told Syed that the library had a surveillance system inside the building. In the second letter, McClain again referred to their conversation at the library that day. In addition, trial counsel's file contained notes from her law clerk of an interview with Syed on July 13th, 1999, wherein Syed said that McClain, quote, saw him in the library at 3 p.m., end quote, and her, quote, boyfriend saw him too. Trial counsel also noted in her file that McClain plus boyfriend saw Syed in the library 2:15 to 3:15 p.m. Finally, trial counsel was aware, at least 6 weeks before the second trial, that McClain's alibi testimony probably covered the same time period as when the state theorized that Hayes' murder occurred. Therefore, we conclude that Syed's trial counsel had the duty to investigate McClain as a potential alibi witness, which required counsel to make some effort to contact McClain to ascertain whether her testimony would aid Syed's defense.
Ooh, so he really came armed with information that he claims should have been investigated. But remember what we talked about in the last episode. It's not good enough that there was some bad judgment call by your attorney for it to be ineffective assistance counsel. You have to show that you were prejudiced by it. Now, did this deficiency by Syed's counsel prejudice him? Yes, the court said, because, quote, it is our opinion that if McClain's testimony had been presented to the jury, it would have altered the entire evidentiary picture, because her testimony would have placed Syed at the Woodlawn Public Library at the time the state claimed that Syed murdered Hay. And you can see why the court would have reached that decision, because we're not saying we know what McClain would have said. We're just saying there is enough there in order to warrant investigating. And why this is so important is back to what Brett said, because of that incredibly tight timeline that the prosecution has built from 2:15 to 2:35 for this murder to have occurred. Remember, Syed, as the defendant, does not have the responsibility of providing the real story of what happened that day. All he has to do is show reasonable doubt to the jury. And if the prosecution is forcing themselves into a 20-minute timeline, all he has to show is that he could not have killed Hae Min Lee within that 20-minute period. He doesn't have to show, that writ large, he couldn't have killed her at all. All he really has to do is say, it is impossible for me to have done this in the timeline that you have raised. And it appears that McClain would be a witness who could place him somewhere other than the Best Buy parking lot or other than anywhere with Hae Min Lee. Therefore, potentially rising to the level of reasonable doubt and changing the outcome of the trial, therefore leading to a potential prejudice to Syed. So with all of that said, the new trial that the court granted Adnan Syed should be starting any day now, right? Well, no, because the Maryland Special Appeals Court saw it one way, but the Maryland Court of Criminal Appeals saw it another.
So you have this victory by Adnan, but as we all know, if you win in one court, you may get appealed to another. And he gets appealed to the Maryland Court of Criminal Appeals. And they agree with the lower court on a very important point that, quote, a trial attorney's failure to investigate a potential alibi witness ordinarily will fall below the standard of reasonable professional judgment because it undermines the adversarial testing process inherent in a contested case. At a minimum, due diligence obligated Mr. Syed's trial counsel to contact Ms. McClain in an effort to explore her potential as an alibi witness. An attorney cannot be said to be carrying out the requirement of due diligence without conducting a factual investigation of an alibi witness who claims to have knowledge of the defendant's whereabouts on the day of the crime in question. So the court's very clear On the first prong, ineffective assistance, deficient performance, nailed it. Syed has shown that. Counsel was clearly deficient. They should have investigated this witness.
But then the court turned to the second question. Did this failure prejudice Syed? To determine this, the court looked to the totality of the evidence, and here is what they said. With that in mind, we highlight some of the more crucial evidence the state relied on to prove its case. Mr. Wilds testified that Mr. Syed had complained of Ms. Lee's treatment of him and said that he intended, quote, to kill that bitch. Mr. Wilds claimed to have seen the body of Ms. Lee in the trunk of her car at the Best Buy parking lot. Ms. Pusateri, a friend of Mr. Wilds, told police and testified at trial consistent with those statements, that Mr. Wilds told her that Ms. Lee had been strangled. At the time Ms. Pusateri relayed this information to the police, the manner of Ms. Lee's death had not been publicly released. Mr. Syed's cell phone records showed him receiving a call in the vicinity of Leakin Park at the time that Mr. Wilds claimed he and Mr. Syed were there to bury Ms. Lee's body. Mr. Wilds directed the police to the location of Ms. Lee's abandoned vehicle, which law enforcement had been unable to find for weeks. Mr. Syed's palm print was located on the back cover of a map book that was found inside Ms. Lee's car. The map showing the location of Leakin Park had been removed from the map book. Various witnesses, including Ms. Pusateri, Nishatana, and Christina Vinson, testified to either seeing or speaking by cell phone with Mr. Wilds and Mr. Syed together at various times throughout the afternoon and evening on January 13, 1999.
So why is all that important? We talked about prejudice. We've talked about prejudice many times. And prejudice comes up in almost every facet of an appeal. Mistakes happen, deficient performance happens, errors are made, but ultimately you have to show a probability that those errors would have resulted in a different outcome. So essentially what the court is saying is, imagine that Asia McClain had testified and that she testified to everything that Syed says she would testify to. Would it have changed anything? Let's look at that testimony up against all of this other evidence. And here's what they concluded. Given the totality of the evidence the jury heard, we conclude that there is not a significant or substantial possibility that the verdict would have been different had trial counsel presented Ms. McClain as an alibi witness. Ms. McClain would have been an alibi witness who contradicted the defendant's own statements, which were themselves already internally inconsistent. Thus, Ms. McClain's proffered testimony could have further undermined Mr. Syed's credibility. Moreover, Ms. McClain's account was cabined to a narrow window of time in the afternoon of January 13th, 1999. Her testimony would not have served to rebut the evidence the state presented relative to Mr. Syed's actions on the evening of January 13th, 1999. At best, and this is important, at best, her testimony would have highlighted Mr. Syed's failure to account precisely for his whereabouts after school on January 13th, 1999. Trial counsel's deficient performance, therefore, could not have prejudiced Mr. Syed in light of the totality of the evidence presented to the jury. Ultimately, the post-conviction court reached the same conclusion as we do here. That court viewed Ms. McClain's testimony in the light of the crux of the state's case, which did not rest on the time of the murder. The post-conviction court reasoned that the state placed Mr. Syed in Leakin Park at approximately 7 p.m. on January 13, 1999, through the testimony of Mr. Wilds and the cell phone location evidence. With this theory in mind, the post-conviction court concluded that Ms. McClain's testimony would not have been able to sever this crucial link between Mr. Syed burying Mrs. Lee's body and the state's evidence supporting that allegation. So what are they saying here? They're saying, on the one hand, this statement about where he was in the library, it actually contradicts some of the things he said. At some points, he said he was with the track team, for instance. Now, all of a sudden, you're going to have an alibi witness who says, no, what he said isn't true. He was actually at the library. I know that because I saw him there. There's also some discussion about how the library was a place that people met for rides. And there was testimony that Hae-Min Lee was supposed to give him a ride that day. And in fact, that was the ruse by which he was able to get her in the car and murder her. So the court's saying, look, even if you had this, it doesn't help you maybe as much as you think, and it might even help you. But the bigger point, and this point they make here at the end, this really only serves to contradict the state's own theory. The state has a theory, and it says we think it happened in this narrow period of time. But that doesn't mean the state's right. And I remember listening to Serial and not really understanding why no one made this point. There's no, other than that telephone call that we don't even know where it came from, there's no reason to actually think that she was dead that early. She could have been killed later on. And if you listen to Serial, the timeline for when she was probably killed moves around a lot. And it tends to move later in the day as the episodes go on. And if that's the case, it's a situation in which McClane may well have seen him there at the library, and yet he still killed Hae-Min Lee. Now, there is a dissent from this decision, and the dissent takes issue with this point because they're kind of like, look, the state's the one who said that. So you may be right, but the state was the one saying that. They put it on at trial, and it would have hurt them if you have an alibi witness saying, well, that's not exactly true. And while that may be the case, you also have to think about this and sort of, it's like a meta way of thinking. Because if Aisha McClane was going to testify that she saw Adnan at 2:30 at the library, guess what? The state probably would have moved its timeline. So it's kind of like this ping-ponging back and forth trying to figure out if this had happened, would it have had any effect? And that's why you see this sort of mountain of evidence put forward by the court to support its finding that yes, this is deficient, but no, it's not prejudicial.
And that's so helpful to not just stop at one opinion, because we heard a lot about the new trial being granted, and a lot of people kind of interpreted a new trial being granted with acquittal. And that is not the case, especially when there are additional courts of appeals to appeal to, which happened in this case. And that's why it's very important to follow the entire legal procedure of a case to fully understand what happened here.
And I'll tell you one thing I think is really interesting about this case is at least the people who wrote this opinion are really sending a signal about what they think is the strength of the state's case. And they apparently think it's pretty strong because ordinarily, if you're doing this ineffective assistance of counsel thing, because if you lose either prong, the defendant loses. Oftentimes, courts don't even address the deficient performance question. They don't even get into that because that's like often much more complicated than the prejudice question. So they just say, there's no prejudice, we don't have to worry about this. So for this court, and maybe it's because this is a famous case, I'm not sure, for this court to actually go ahead and say, look, yeah, sure, she was deficient, but it wouldn't have made any difference, to me sends a signal about the strength of the case. Because usually, if a court finds you to be deficient, prejudice kind of follows, because usually they don't get to deficient performance unless they're going to find prejudice. So for them to find her deficient, to say that he's able to do this thing, which is really hard to do, which is show deficient performance, and then nevertheless say, even though she was deficient, you still lose because there's no prejudice here. It speaks to the strength of what they thought about the state's case. Now, they're not taking into account any of the sort of post-trial investigation or anything you've heard on the various podcasts that have covered this about how strong is the cell location data or is Jay Wiles actually believable. They're not taking any of that into account because none of that is part of the record in front of them. The only thing they consider is the record. And Jay Wilds testified, and the jury found Adnan Syed guilty, which means there's a presumption that they found Jay Wilds to be credible. And since they found him credible, everything he says is just a huge weight against Syed when he's trying to make this prejudice claim. It's just very difficult to overcome a testifying witness who is your accomplice, who says they helped you bury the body. It is really hard to overcome that, no matter what your counsel might have or should have done.
And some of you may be thinking, well, then it's still not fair that his counsel clearly didn't investigate some very seemingly valid claims or avenues to pursue. Remember, attorneys are people who have limited resources, and preparing for a murder trial, either the prosecution or the defense is a around the clock type of job. And so you chase down as many leads as you can. You're preparing your witnesses, you're preparing your theories, you're trying to read through all of the discovery if you're the defense to know who's going to testify and how you're going to cross-examine each of them. It's not like his attorney was sitting back with his feet propped up doing nothing. It happens that this is one avenue that he didn't pursue. It doesn't mean he was doing nothing. And it's easy from the outside or hindsight to kind of poke and pull at threads that weren't investigated by an attorney. But know that the reason the bar is so high that you have to show this prejudice in order to show ineffectiveness of counsel is because the courts recognize and know that these attorneys are faced with basically a fire hose of information, of discovery, of potential strategy paths. And it is very easy, and it is impossible not to be able to point to one aspect of a case that an attorney or a defense did not pursue, that perhaps in hindsight could have bore some fruit. So just know that you have to view it not in a vacuum, but in the reality of what it is like to be at trial.
So in the end, this appeal failed, as they typically do. And this is an ongoing case. As most of you know, it's very controversial. There's some DNA testing going on now. Who knows what that will reveal, if anything. I'm sure this case will continue to be litigated for quite some time. But this question about effective assistance of counsel is basically foreclosed. If there is a new trial sometime in the future because of DNA evidence or whatever, I would expect Asia McClain would testify, and 20 years later, she would finally get to say her piece, and you would see what effect that had. But of course, he'd have to get to a new trial first. So I know many of you would like us to spend 8 or 9 more episodes on this case, and maybe one day we will, but that's not really for Legal Briefs. That's more of our main podcast pursuit. So one day, I promise, we will do this case, but not for now. We did get one question I wanted to address that has nothing to do with Adnan Syed or ineffective assistance of counsel. This person, Jay, I'll just say Jay, says, "Thanks for another great episode. I do have a question. I watch many different crime dramas, domestic and international. I have noticed that in the U.S. dramas, the lawyer will do most, if not all, talking for the suspect. On the other hand, in the European dramas, the lawyer is in the room during the interrogation, but they say nothing or very little. Why is that? Thank you in advance." Well, I guess that's probably just because of how dramatic you want it to be. And usually in the United States, the dramas are all about the lawyers. So the lawyers are going to be the ones doing the talking. In reality, lawyers don't say a whole lot. And it doesn't really matter if you're the prosecutor or the defense. The interrogations, it's not like it is in Law and Order, where the prosecutor is the one asking all the questions. We have investigators and agents and officers for a reason. They are trained in interviewing suspects and witnesses. And although we are often in the room, and while we will occasionally do some talking and ask some questions, primarily it's the job of the investigators to investigate the crime and to ask questions of the witness or the suspect or the target, whatever you want to call them. And then they will do most of the talking, though obviously occasionally their defense attorney will step in as well.
And also know that when there is an interrogation or an interview with a witness or target, it's not good enough per se for the attorney to say it. That's kind of called an attorney proffer. We need to hear the actual witness or suspect say it from their own mouth. So oftentimes you'll see kind of more savvy attorneys step in and say, well, what he means to say is he thinks there were drugs in the house when the police came. And we have to say, well, what does he have to say? And we ask for him to say it in his own words. Because remember, it's not his attorney that will be testifying on the stand if he were to testify. It is the words of the suspect or the target or the witness, whoever you're talking to, that matters. So attorneys are there to protect their client. But at the end of the day, the testimony has to come from the actual fact witness.
So I hope that answered your question, Jay. Being a lawyer is just as dramatic and exciting and constant action as they show you on the television shows. I promise. It's never boring. It's just like that every day.
It's definitely
every
not.
day.
It's definitely not. But it's because you have to do a lot of research and a lot of preparation in order to prepare for those kind of dynamic moments that you may see on TV. So just like in every other profession, in every other aspect of life, preparation is the hard work you put in before you get to do the exciting dynamic parts that are captured on TV. Well, with all that said, I hope you guys at least got a bit of your fix with Adnan Syed. And as always, please write in with your questions, with your thoughts on whether you think the Maryland courts got it right or not. This continues to develop, and we love hearing from you all. Thank you for your support as we have been getting legal briefs off the ground. We have just been blown away by your 5-star reviews and your encouragement on our social media pages, and also all of you on Patreon who get both our Prosecutors podcast and Legal Briefs episodes ad-free. Thank you guys for your support. We hear what you are saying and we appreciate you. With all that said, is there anything you'd like to add, Brett?
No, I don't think so. Just will say, I hope it's obvious as we're early on in this show that we are definitely taking what you want to hear seriously. So we covered this issue because this was a thing people had asked us to cover, and we will continue to do that. So be sure to send those questions our way.
Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. Wrong one, yeah.
In the case how do you actually pronounce that?
Judice? I don't actually know.
It's just I don't use this kind of legalese in my writing, so I don't actually know how to pronounce it.
Let's see. I'm looking it up. Subjudice. Subjudice. That makes sense.
Judice. Okay. In the case